Welcome to Operating with Positive Impact, a brand new series of podcasts brought to you by PwC. My name is Anthony Nev, and throughout this series, I'll be your personal guide in shaping your organization into a sustainable business. Together, we will deep dive into the world of sustainability and its impact on a business world. In our last episodes, we delved into various aspects of sustainability, and frequently we touched upon the important role regulations are playing in driving changes. In this episode, we will specifically focus on those regulations and the legal trends that are pushing companies to transform themselves. We will be exploring emerging regulations, court actions involving the general public, government and companies. And finally, we will be exploring how businesses are adapting to these new legal dynamics. To navigate these critical trends, let's hear about the insights of Els and Pierre from PwC Legal.
Welcome to this episode on the legal framework for ESG. My name is Empereur. I'm a director at PwC Legal. I'm the head of public law, and I've been practicing environmental law and ESG since many years now. With me is Pierre Queritet of PwC Legal. Pierre, maybe you can introduce yourself shortly.
Thank you, Els. I'm responsible or co-responsible for corporate and M&A. And I have been, since a couple of years, following sustainability, namely from the governance angle, so the G in ESG.
Okay, so today we are talking about the legal framework for ESG. Why is legal important in ESG? Well, our book, How to Operate with Positive Impact, provides a roadmap on how to embrace ESG in your business. It explains what ESG encompasses, how to understand it, how to implement it, and a whole chapter in it is dedicated to the legal framework, and for a reason. Legal sets the minimal requirements, the baseline, as you can say, for all companies, and all companies should at least comply with this legal baseline. Compliance with ESG regulations ensures responsible behavior, it mitigates the risks, and this ESG framework, legal framework, is constantly evolving, becoming more and more complex and presenting many challenges for companies. But compliance should not be the sole driver for ESG adoption. The legal dimension goes beyond mere compliance. It empowers companies to proactively integrate ESG considerations into their operations. It drives positive social and environmental impact.
Yeah, in my practice, that's namely interacting with corporate counsels and general counsels, and you named it, complexity is a reason, I think, why they get more and more involved in the ESG topic in their organization. Complexity is one thing because that can lead to risk, and then you have general counsels and corporate counsels that are actually responsible or co-responsible in the end for managing the risks in their organization. It is not anymore a matter of soft law. It's clearly a hard law topic with concrete obligations, sanctions, etc. A reason why, again, the councils are more and more involved, and not just the sustainability officer at the organization or the chief engineer. If you name somebody who has been since years already involved in sustainability. Why is it now such a complex topic? Because the EU has clearly chosen to be one of the front runners with the Green Deal. They have enacted a lot of hard laws, EU level, and that is both regulations which directly apply, but also directives which need to be transposed into national law. And then at a certain point in time, all those instruments, they might or might not fully or not fully apply to the organization. And then, of course, it is often a matter of a legal scrutiny to identify when does an instrument come into play for my organization, how wide is it affecting my organization, and when is it entering into force for my organization. And that's clearly where we see the legal counsels coming more and more at the discussion table, actually to support their teams internally to find the right answers to all those questions. The EU Green Deal, maybe have a look at the EU Legislative Train website. It's impressive. There's a lot of initiatives that are either in draft or just an idea, but a lot of them are almost entering into a legal hard law status. If you're an international group, you're the Belgian Council of the European headquarter of I'm inventing something, a Japanese group, they will ask you out of Tokyo, advise us, how does the EU Green Deal legislation interact with the Japanese sustainability laws? Is it a matter of Japan taking the lead and EU following, or vice versa? Who is in scope, who is not in scope? All those questions are very interesting. Japan, the US with the SEC, Hong Kong, they all have their own instruments, and so we need to find out how they interact.
Indeed, Pierre, the scale and speed of these changes can be overwhelming. And managing liability and risks, including litigation risks, is a critical part of our role as lawyers. So we are currently witnessing a correlation between this wave of environmental and ESG legislation and an increase in court decisions. Because really environmental litigation, climate cases, is really on the rise globally. You see it in the US, the UK, Australia, and the EU. They are leading in case volume, and we already see some landmark cases that set precedents for future cases. So it's already a hot topic, definitely a hot topic. And these climate-related litigations are not only aimed at companies, sometimes also at directors, individuals, but also at public authorities. And most of these cases are brought by associations such as Klimaatzaak, Client Earth, Greenpeace. And this is facilitated by the Treaty of Aarhus, which is a very important treaty because in this treaty, environmental transparency is regulated, and also the right of the public, of every individual, of every association, the right or the access to justice. So it grants or it ensures that everybody has a chance for a review by a court or another independent body. And so this treaty really facilitates the access to justice and is one of the reasons there are so many climate cases going on now. If you look at these climate cases, there are mainly two legal grounds where they're based on. One of them is the human rights. Human rights as protected in a lot of international treaties and in constitutions. And the human right here is the private life, or the right to a private life, a family life. And this includes the right of to a healthy life. So this is the basis of many of the climate cases that we see. We had, for instance, the recent case in April of this year of the Klimaseniorinnen against Switzerland. And these elderly ladies, they had Switzerland on trial for inadequate action on climate change, impacting their health and their living conditions. So it becomes, I must not say that it's, excuse me, that it's easy to start litigation, but this treaty really facilitates it. Of course, there are some limitations. You do need a connection with the affected natural area, and you need first to exhaust all domestic courts. Otherwise, you cannot proceed to a trial before the European Court of Human Rights. That's the Court of Human Rights. Another of the grounds for litigation is torts law. but you're more. Maybe you can talk about that later on because you're really a specialist in that. Maybe I want to showcase some of the important climate cases of the last years in the different European countries. The first one in 2019 already was the Urgenda case in the Netherlands. And it was the first of its kind. It was the first judgment in the world in which citizens established that their government has a legal duty to prevent dangerous climate change. Then there was, of course, also the litigation in France, l'affaire du siècle, as they say. Also because the French government did not meet its climate obligations. And then, of course, there is the Klimaatzaak in Belgium, the recent case, also based on torts law and on breach of the right to a healthy life, in which the two regions and the Belgian state were convicted for not complying with their international obligations on climate change. But Pierre, of course, these are cases against public authorities, but I'm sure you know of cases against private companies as well.
Well, I'm witnessing indeed higher attention from, again, the councils, the general councils, the corporate councils. And why is that? On top of the type of cases that you mentioned, where there's a state involved in a environmental organization or a consumer organization, we do see that private companies are now also being summoned more often in court for ESG matters. And they can be summoned again by environmental organizations, and that's indeed the first trend that we see, with again a landmark case that was also in the public media. It's about the energy group Shell, and where a Dutch environmental organization is indeed trying to have that company sentenced because of not respecting what they call the general duty of care and respect for ESG matters. It's in appeal now, so everybody is indeed very curious how that will end and land, because that might indeed trigger other cases against the private companies. Greenwashing is another delicate situation where the councils might indeed be considering disclosures of ESG, and where they might indeed encounter that the disclosure has not been accurately done or not fully done, and then that could lead to a case based on what we call greenwashing against a private organization again. Another category, else, I'm not sure if you picked that up already when you talk to your clients, is that the directors in person sometimes seem also to be subject of a case. There was one in the UK, and we clearly see UK and the Netherlands, both countries, they have more a trend, not only a trend, but a practice of litigating against companies in ESG matters. So this one is again UK-based, client Earth, again against Shell, but the board of directors of Shell. That one has not resulted in a sentence against those directors, but at least this is clearly a new trend. So acting against the directors personally. And the last that I expect to take place is companies against companies. Companies against companies. Imagine you're a big producer and you have suppliers. And those suppliers, they have not been transparent as regards the ESG components of their supplies. And you, as a big company, have purchased a lot of volumes from that supplier. And of course, you have tried to protect yourself in the contract. And it seems that supplier has not been cooperating or even been greenwashing against you. So I expect also between businesses that actions could be started before the courts or the arbitration panels in connection with ESG matters. And so a lot of risk about litigation, but of course it's better to prevent litigation and to have a strategy than to go to court. But if you need to go to court, then so be it.
Okay. Well, maybe Pierre, I can focus now a bit on the environmental matters, environmental law matters, the E and ESG. The environmental aspects are really numerous. There's not only the European climate law that needs transposing in national law, but there are regulations in the energy sector, the transport sector, regulations on water, biodiversity, nitrogen, deforestation, land use, and so on. And these matters are really important for all our clients, for their business, because everybody sometimes everybody will need an operating permit or building permit, and then all these environmental aspects play a significant role. As you can see in the INEOS case, I named this case because it really highlights how difficult it sometimes is to transpose a European regulation in a national one. This one was concerning the nitrogen problem. We have a nitrogen regulation of the European Union, in which Europe imposes to manage nitrogen emissions and the impact of the nitrogen on special protection areas, called the Natura 2000 network. And this EU-wide network is a network that, and the directive aims to protect these valuable and threatened species and habitats in the Natura 2000 network. And member states are obligated to maintain or to restore these sites to a favorable conservation status. But what is this favorable conservation status? Every member state has to transpose that to national regulation. And that is really difficult because when we see what happened, for instance, in the Flemish region, is that they had a new regulation on nitrogen. It was annulled by the Court of Justice in 2021. They're now trying for a new regulation, but there was also already a critical opinion of the Council of State. And now there is a new decree, but it is attacked before the Constitutional Court. So a permit for an operation, for an industrial activity, an agricultural activity that deposits nitrogen, needs a permit, and in that permit, that the permit should be based on an environmental impact assessment in which is decided upon the impact on the area. But how to do that is not clear, not in European legislation, and therefore also not in the national legislation. So this is something that will really prove to be very difficult indeed. There's also the recent nature restoration law. It was adopted by Parliament in February of this year, but now the European Council still has to decide on it. It's also a very strict regulation, and under this regulation, member states will be required to restore at least 30% of the habitats that are in poor condition by 2030. And in order to do so, all the member states have to submit national restoration plans describing the measures to reach a target. But also this new legislation means new restriction on operation and building permits. So I have a lot to be busy with, but I guess, Pierre, you also have a lot of ESG matters in your practice as a corporate lawyer.
Yeah, absolutely, Els. And there are two angles to that. First, I want to highlight is the impact of ESG on contracting. And I already alluded to it, that while I would say environmental obligations or respect of human rights have sort of in the big international contracts always found its place in that contract. with an obligation, and in case of not following that obligation, a sanction. But we now clearly see it more and more becoming a best practice to have tailored ESG clauses in contracts, and not only between the big multinationals, but also the Belgian SME market. If you're an SME and you're supplying to a big German multinational, you will see that in the supply contracts that German multinational wants you to sign as a Belgian SME, that you will see clauses like a right to audit from that supplier, the right to audit your own supply chain and your own ESG parameters and respect thereof. As a SME, you need to reflect on whether you can indeed allow such a right to audit. And in a lot of cases, you will not have the burden of choice, because it's actually probably one of your biggest customers, so you do not want to lose that customer. And so you say, okay, I agree with that clause, but then when push comes to shuffle and there's a problem, that could mean that you lose that client anyway. So you need to reflect, even as a Belgian SME, on the impact of ESG on your contracts. Something again from the Green Deal perspective that will fuel this is the CSDDD. That's a Corporate Sustainability Due Diligence Directive, which sort of is voted and will be officially adopted in the days to come, and will find its way into national legislation, and actually imposes businesses that are in scope, and it's indeed again the big companies that are in scope, is to install due diligence processes on their entire supply chain. And that directive also imposes those companies that are in scope to include remedies into their contracts, just for the case when their contracting party is not cooperating sufficiently on the data transmission needed indeed for the company in scope to comply with its obligations. And the ultimate remedy is even that the companies should reflect on a termination of the contract for cause as an ultimate remedy. So even being put against with your back against the wall, so to speak, in case there's a serious issue. So that will fuel again the impact of ESG into the contracts. To end with a specific type of contracts, which I do a lot in practice, is M&A. Share purchase agreements, they always had their sectional representations and warranties for environmental and social laws, but you will now see more and more tailored ESG reps and warranties and indemnities. Also the due diligences that are being conducted on target companies will more and more have a dedicated section on ESG hard laws. So that was one else, that's contracts. And then a second important one is the perspective of the director and the personal liability of the director, where I indeed already alluded to some flagship cases. But it's not only waiting for the flagship cases. I think every director, and in Belgium you have a duty of care, which is a reasonable duty of care, but you will need to reflect as a director, also looking forward on how your organization, to which you are accountable, towards your shareholders, but also the stakeholders, is as a director, you need to look into the future and reflect really on the importance of ESG for your business, but also for your own liability's sake. Because your duty of care is not only to comply with a certain law and compensate if you breach the law. No, as a director, and all those cases, they actually justify this forward-looking obligation that directors now have. You really need to reflect on how can I, as a business, contribute to a more sustainable environment, a more sustainable workforce looking forward, and how can I already right now take the measures needed to prevent that on the midterm, 5 to 10 years time, there would be a big issue popping up. So looking more into the future, putting that also not just in soft policies, but actually following up on that internally and act upon. So we clearly see a shift in that duty of care to more action, proactivity, and looking forward rather than just looking at the moment itself.
And don't you think, Pierre, that an important role is there for the environmental coordinator? It's a special legislation in the Flemish region that some companies, big companies, need an environmental coordinator who ensures compliance with environmental laws, oversees emission measurements, maintains waste registers, material registers. I think there's an important role for this function as well.
Yeah, you mentioned that specific function that already was created before ESG sort of
95
became a hot topic. But that role of that person indeed is increasing. But what we also see, and I'm not talking about the small businesses, but the larger corporations, they're actually interrogating internally and also asking our advice in that respect, is on shouldn't we install a dedicated committee bundling all the people in the organization that actually have not just an interest in ESG, because it's more than corporate social responsibility, it's not CSR, it's hard law, as I said, is putting the people together in a dedicated committee that is actually reporting directly to the ExCom or to the board, and has also clear responsibilities and also a clear action list, and needs to follow up upon that action list on an annual basis. So I do see more and more companies looking at creating a dedicated ESG committee, bundling a lawyer, a sustainability officer, the milieu coordinator, etc. And I do not rule out that in the future there will even be a change in the company law for the big companies installing a mandatory ESG committee. But that's I would say not for the short term.
Yeah, maybe as a conclusion, Pierre, I think it's fair to say that the legal landscape for ESG is still evolving, both on a European and a national level, with new obligations to come, new risk, but also opportunities for our clients, and for us, an important role in managing liability, risks, compliance, and other challenges.
Yeah, it's about the General Counsel indeed contributing to a more sustainable economy and a more sustainable future.
What strikes me across all the episodes is the shift we are seeing on our expectations of companies. In the past, we were expecting them to focus on financial growth in compliance with regulations. We expected that having companies focusing on financial growth would indirectly bring wealth to everyone. Companies had an indirect objective to create wealth in the end. Sadly, this system showed its limits, and now the indirect objective is shifting towards a direct expectation. Today, we are expecting companies to play a direct role in creating wealth for humanity now and securing it for the future. The increasing amount of regulations linked with sustainability are only a materialization of this new trend. In my view, regulations are there to show us the way we as a society want to evolve. It is again up to us to lead the change towards a sustainable future and embrace this new trend.